Hah? Kenapa begini? Kenapa begini? Kenapa begini? Kenapa begini? Kenapa begini?
Nanti nggak ikut kelas.
Cek. Ada. Cek.
Ada. Oke.
Mana tadi yang kamu dulu?
Ladies and gentlemen, brother and sister, Assalamualaikum warahmatullahi wabarakatuh. Let's open this conference. That you mute your microphone so there will be no noises during this session. Thank you. First of all, let's say thanks to Allah Subhanahu wa Ta'ala, because of His blessing, we're able to join this conference. Secondly, salawat and salam as we deliver to our Prophet Muhammad SAW, who has guided us from the darkness into the brightness. The Honorable Dr. Kelik as the Dean of Faculty of Law University of Surakarta, the Honorable LL.M as the head of study program University of Surakarta, honorable all speakers, and my beloved partner. I am ICRTLAW. Well, ladies and gentlemen, before we start, I'd like to read the list of agenda today. The first agenda is study. The second agenda is the reading of Holy Quran. The third agenda is sing a song Indonesia Raya and Sang Surya. The fourth agenda is opening speech by Mr. Andrea Luhur Prakoso SHMKN. The fifth agenda is the main session. They are speech by our wonderful keynote speakers today, and will continue question and answer session and concluding remarks by moderator. And after that, we'll continue to parallel session. And the last is the closing. Before we start, I would like to inform you that today we will have a wonderful presenter. First speaker will be delivered by Prof. Wardiono, SHMH, the Dean of Fakultas Muhammadiyah University of Surakarta. The second speaker will be delivered by Prof. Husna from University of Kuala Lumpur. And the third speaker will be delivered by Dr. Yusramizza from Universiti Utara, Malaysia. Ladies and gentlemen, now let's jump into our first agenda. There is the Holy Quran. It will be read by Gilang Rahman. Gilang Rahman, time is yours.
Assalamualaikum warahmatullahi wabarakatuh.
Salam.
أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. ولله ملك السماوات والأرض والله على كل شيء قدير. إن في خلق السماوات والأرض واختلاف الليل والنهار لآيات لأولي الألباب الذين يذكرون الله قياما وقعودا وعلى جنوبهم ويتفكرون في خلق السماوات والأرض ربنا ما خلقت هذا باطلا سبحانك فقنا عذاب النار ربنا إنك من تدخل النار فقد أحصيته وما للظالمين من أنصار ربنا إننا سمعنا مناديا ينادي للإيمان ينادي للإيمان أن آمنوا بربكم فآمنا ربنا فاغفر لنا
Recording in progress.
وكفر عنا سيئاتنا
Alternatif law
وتوفنا مع
kan di background.
الأبرار ربنا وآتنا ما وعدتنا على رسلك ولا تخزنا يوم القيامة إنك لا تخلف الميعاد صدق الله العظيم السلام عليكم ورحمة الله وبركاته.
Alhamdulillah, thank you very much, Gilang. May we all get syafaat in this life and hereafter. Amin. The second agenda is sing a song Indonesia Raya and Sang Surya. Ladies and gentlemen, could you please standing in your place and then singing together?
Sadaqallahul azim. Assalamualaikum warahmatullahi wabarakatuh.
Alhamdulillah, thank you very much, Gilang. May we all get syafaat in this life and hereafter. Amin. The second agenda is sing a song Indonesia Raya and Sang Surya. Ladies and gentlemen, could you please standing in your place and then singing together?
Sadaqallahul azim.
Alhamdulillah, thank you very much, Gilang. May we all get syafaat in this life and hereafter. Amin. The second agenda is sing a song Indonesia Raya and Sang Surya. Ladies and gentlemen, could you please standing in your place and then singing together? The second agenda is Husna and Sang Surya. Ladies and gentlemen, please stand in your place and listen. The second agenda is Husna and Sang Surya. Ladies and gentlemen, please stand in your place and listen. The second agenda is Husna and Sang Surya. Ladies and gentlemen, please stand in your place Thank you very much for all of the participants. Ladies and gentlemen, the next is opening speech by Mr. Andrea Luhur Prakoso, SHMKN, the Head of Study Program Faculty of Law Muhammadiyah University of Surakarta. Mr. Andrea Luhur Prakoso, time is yours.
Thank you for the Master of Ceremony. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin wassalatu wassalam ala asrofil anbiya'i wal mursalin wa alihi wa ashabihi ajmain amma ba'du. The honorable guest speakers, Professor Dr. Yusramizza binti Muhammadiyah from University of Utara, Malaysia. Dr. Husna Sarirah Husin from Universiti Kuala Lumpur. Professor Dr. Kelik Wardiono, SHMH, Dean of Law Faculty, Muhammadiyah Surakarta University, and also one of our speakers today. And then Dr. Wardiono, Chairman of the committee, and all committee members, and also all the seminar participants. First, let us pray and thanks to God, Allah Subhanahu wa Ta'ala, who has given us His mercy and blessing, so we can attend this seminar today without any trouble and obstacle. Secondly, salawat and salam are always be delivered to our Prophet Muhammad Sallallahu Alaihi Wasallam, who has been fighting for Islam and guiding us on the path of Allah Almighty. Ladies and gentlemen, furthermore, allow me to, on this good occasion, to give a speech representing Law Faculty of Universitas Muhammadiyah Surakarta. Today, we see the challenges of legal science in dealing with a very fast changing era, the digital era, post-pandemic, and also many of various issues require responsive legal transformation and development. And therefore, we are holding this second ICRT LAW seminar with the themes of transforming and development law to contribute ideas to the students, lecturers, and legal practitioners in facing various challenges going towards. A part of that, organizing this seminar is also proof that Law Faculty of Muhammadiyah Surakarta University continues to develop a good academic atmosphere and also efforts toward a world-class university. Next, I would like to thank all the speakers who are willing to attend this seminar today, all the committee's members who work hard for the success of this event, and also all the seminar participants. And finally, let's start this seminar together by saying Basmalah. Bismillahirrahmanirrahim. I think that's all I can say. I hope this seminar runs well and gives a lot of benefit for us. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Mr. Andrea, for your wonderful speech. Ladies and gentlemen, now we will begin the discussion, International Conference Restructuring and Transforming Law. This session will be moderated by Mr. Fahmi Fairuzzaman, SHMH LL.M, as the Lecturer, Faculty of Law, University Muhammadiyah of Surakarta, and for our moderator, time is yours.
Okay, thank you, MC, for the time. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirrabbilalamin. Wassalatu wassalamu ala asrofil anbiya wal mursalin wa ala alihi wa sahbihi ajma'in amma ba'd. Good morning, ladies and gentlemen, the speakers and all of the participants. First of all, let's say thanks to Allah Subhanahu wa Ta'ala, who has given us guidance, happiness, healthy, and mercy, so we can attend and participate in this special event without any obstacles. Praise and salutation upon our Prophet Muhammad Sallallahu Alaihi Wasallam, who had brought us to the path of light from the darkness in this life. Welcome to the second International Conference on Restructuring and Transforming Law, or the second ICRT Law. The COVID-19 pandemic has brought about a dramatic change in social life, where humans are more likely to keep their distance, socialize in a limited manner, and with health protocols. This change in social attitudes poses its own challenges for the law in Indonesia, especially a pandemic that is followed by a pandemic that is followed by a crisis creates a situation when society and the law are transformed according to social change. The transformation and restructuring of the law are a challenge that arises during and after the pandemic, right? The current situation, as a consequence of the social changes that occur in the society. Regarding this phenomenon, the Faculty of Law, Universitas Muhammadiyah Surakarta, is proud to hold the second International Conference on Restructuring and Transforming Law, or ICRT Law. Today is all about uncovering the transforming and development law in the new post-pandemic era. Before going any further into the main session, I would like to warmly welcome today's speakers. The first is the Honorable Professor Dr. Kelik Wardiono from Faculty of Law, Universitas Muhammadiyah Surakarta. The second is the Honorable Dr. Husna Sarirah binti Husin from Information System Department at Universiti Kuala Lumpur Malaysian Institute of Information Technology, or UNIKL. And the third is the Honorable Professor Dr. Yusramizza binti Muhammadiyah from School of Law, Universiti Utara, Malaysia, as well as participants of today's international conference. Thank you so much for joining us today. And before we get started with the main session, I'm going through some housekeeping to ensure the participants can interact with myself and the speakers later. First, the main session will be divided into 3 sessions. Each session will last for approximately 30 until 45 minutes of presentation. And after that, there will be 15 until 30 minutes of question and answer session, or Q&A. During the presentation session, I would like to ask the participants to keep mute their respective Zoom accounts so as not to interfere with the presentation. Secondly, if you wish to ask the speaker a question or some questions in the Q&A session, please use the raise hand feature on the screen, or you also can use the chat room feature to give the question, and I will help to read it to the speaker. And now we move to the main session. The first speaker will be Professor Dr. Kelik Wardiono. Selamat pagi, Prof.
Selamat pagi.
Yeah. Before we start the presentation, I'd like to read a brief introduction to our speaker. Professor Kelik Wardiono is professor from Faculty of Law, Universitas Muhammadiyah Surakarta. Currently, he is the Dean for the 2021 until 2025 period. His areas of expertise are legal philosophy and legal research methodology. He also has many publications, both in the form of books and journal and the others. Some of his works, which have the highest level of citations, including book entitled Legal Research Methodology atau Metodologi Penelitian Hukum, and book entitled Consumer Protection Law atau Hukum Perlindungan Konsumen. Today, Prof. Kelik will talk about prophetic-based post-pandemic law, restructuring and development, atau restrukturisasi dan pengembangan hukum pasca pandemi berbasis prophetic. So, without any further ado, let's begin the presentation session. Pada Prof. Kelik Wardiono, kami persilahkan.
Thank you very much, Mr. Fahmi. Kelihatan ya? Kelihatan Pak Fahmi?
Belum, masih proses.
Sudah terdengar? Belum?
Suara
belum
sudah,
ya?
Prof, tapi presentasi belum.
Ini sedang.
Oh, gitu.
Berat ya. Kalau berat saya coba kirim ke
presentasi sudah terlihat.
Okay, so I think we need to wait some more minutes. I think there is technical problem from Kelik.
belum ya? Dengan saya. Ya. Coba.
Mohon maaf, Prof, suaranya masih terputus-putus.
Putus ya? Ini saya gimana? Bisa nih dari sudah
I'm sorry, Prof. I think the signal is not or unstable. Tidak stabil, Prof. Sinyalnya mungkin.
Saya kirim ke Mas Fahmi.
Oke, baik, Prof. Sorry, I think we have some technical problem here in the campus. Prof. Kelik? Good. We will try again to reach Prof. Kelik. I think there's some bad signal there. So the topic of from Prof. Kelik, it is related or in relation to his dissertation, namely prophetic law, an approach to the basic epistemology of paradigmatics. So this topic is still on his roadmap. It would be very interesting to hear from one of the experts in this topic. But I think, okay, Prof. Kelik is back with us. Prof. Kelik? Okay.
Sudah saya kirim di WA, Mas Fahmi, bahannya. Bisa minta tolong.
Baik, Prof. Saya
Presentasi.
akan bantu untuk share screen-nya.
Untuk suaranya terdengar jelas ya?
Suaranya sekarang cukup jelas, Prof.
Oke, saya sudah di luar. I'm sorry. Oke, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Alhamdulillah, Alhamdulillah. La haula wala quwwata illa billah. Good morning, ladies and gentlemen. First of all, I would like to greeting and welcome you to the Faculty of Law, University Muhammadiyah Surakarta. As of one of 171 Muhammadiyah and Malaysia University and we hope that all of you international conference. I apologize in advance because I cannot speak English well and fluently. So please allow me to send the material in Indonesia. Okay. Di kesempatan ini saya akan mencoba memotret satu fenomena yang terjadi sebenarnya jauh hari sebelum pandemi ada di Indonesia dan kemudian semakin berkembang. Dan di salah satu periode oleh belum masih awal, masih judul. Nah, bagian dari postdoc ini akan saya coba kaji dari perspektif profetik, yaitu melihat dari perspektif filsafat, terutama nanti dilihat dari kajian perspektif filsafat ilmu. Jadi akan melihat bagaimana restrukturisasi dan pengembangan hukum pasca pandemik dilihat dari perspektif filsafat ilmu, terutama di era post-truth. Thanks. Pengertian awal era post-truth atau post-fact. Oke. Next. Adalah sebuah era yang relatif berbeda dengan masa-masa sebelumnya. Ini adalah sebuah masa di mana fakta-fakta objektif itu menjadi Ketika ingin memahami sebuah realitas, perasaan memiliki bobot yang lebih tinggi dibandingkan dengan pendapat yang merujuk di bukti. Terus Mas, berikutnya. Nah, apa yang diungkapkan oleh orang seringkali hanya bersifat pengetahuan. Jadi sebuah fakta yang diolah tidak menggunakan rasio secara benar, tetapi hanya mendasarkan pada common sense saja, yang kemudian disebarkan secara massal meskipun belum terbukti kebenarannya. Next. Nah, sehingga pada saat ini sebenarnya ketika melihat fenomena post-truth, kita tidak sedang berhadapan dengan seorang liar, bukan berhadapan dengan seorang pembohong, tapi berhadapan dengan bullshitter. Apa itu liar dan bullshitter? Nah, akan saya jelaskan di slide berikutnya. Beda dengan hoax, berada di lapisan bawah, yang secara tidak sadar sebenarnya sedang mendominasi kehidupan kita dan kemudian menyebabkan terjadinya perubahan di berbagai bidang. Jadi yang saat ini kita hadapi, ketika di era post-truth, itu bukan seorang pembohong, seorang pendusta, tetapi bullshitter, seorang pembual, seorang yang banyak melakukan omong kosong di berbagai model komunikasi. Nah, pengertian post-truth sendiri ini mulai dikenal sejak November tahun 2016 dan kemudian pada tahun 2016 masuk ke Kamus Oxford karena meningkatnya penggunaan terminologi post-truth sehingga mencapai 2000% selama tahun 2015. Sedangkan fenomena post-truth ini sebenarnya sudah lama. Bisa terlihat dari agresi militer Amerika pada Irak, di mana mereka mencoba untuk mencari kebenaran saat Amerika menyerang Irak, meskipun tidak disertai dengan bukti-bukti ilmiah yang bisa dipertanggungjawabkan, dan sebagian orang kemudian mencoba untuk mempercayai dan kemudian menjadi bagian dari orang yang menyuarakan propaganda yang dilakukan oleh Amerika saat menyerang Iran. Ini juga kemudian terlihat jelas saat ada peristiwa Brexit, yaitu keluarnya Inggris dari Uni Eropa. Demikian juga alasan-alasan yang dikemukakan lebih banyak tidak didasarkan pada eviden-eviden yang bisa dipertanggungjawabkan, tapi alasan-alasan yang lebih bersifat emosional dan merujuk pada kepentingan-kepentingan sesaat. Kemudian lihat sebagai salah satu ikon yang seringkali menyebarkan orang yang seringkali melakukan pembual dan memberikan informasi-informasi yang menjadi sulit untuk diakui kebenarannya. Di Indonesia sendiri, fenomena post-truth bisa terlihat sejak Pilkada tahun 2017 yang kemudian juga semakin berkembang di Pilpres tahun 2019. Yang sekarang kita lihat akibatnya sesuatu yang berada di laten, di ranah tidak terlihat ternyata pengaruh kehidupan, seolah-olah kehidupan di Indonesia dan hadron. Dan ini juga terlihat pada masa pandemi COVID-19 ini. Ini yang kemudian menjadi titik poin bagaimana pengaturan dan pengembangan hukum di era pasca COVID. Next, Mas. Berikutnya. Mas Fahmi, berikutnya. Mohon maaf. Kalau kita lihat dari berbagai peristiwa, terdengar ya Pak Fahmi? Pak Fahmi?
Iya,
Suara
Prof.
saya terdengar. Baik.
Sudah terdengar.
Dari sekian runtutan peristiwa yang terjadi di awal-awal masa pandemi, ada sebuah respon yang diperlihatkan oleh pemerintah Indonesia hingga Februari 2020. Respon yang diperlihatkan dengan melihat istilah yang ada di dunia internasional, yaitu pemerintah merespon dengan apa yang disebut dengan desekuritisasi. Ini sebuah respon yang melihat apa yang terjadi di luar bukan sebagai ancaman terhadap rakyat dan bangsa Indonesia. Ada beberapa informasi yang kemudian terlihat menyepelekan apa yang ya, berikutnya. Next. Kita lihat banyak informasi-informasi yang dikeluarkan oleh pejabat Indonesia di awal-awal masa pandemi. Menkes Terawan Agus Putranto misalnya, menyebutkan kita tidak usah panik dan resah, enjoy saja. Prof Mahfud menyebutkan Indonesia satu-satunya negara besar di Asia yang belum memiliki kasus positif. Demikian juga berikutnya mendiskreditkan penelitian Harvard tentang kemungkinan virus corona sudah ada di Indonesia. Ada yang menyebutkan bahwa virus corona tidak dapat masuk karena perizinan berbelit-belit. Prof Amin menyebutkan bahwa virus corona tidak berani datang karena doa kunut ulama dan istighatsah. Tidak ada virus corona di Indonesia karena virus tersebut tidak berkembang kuat di negara tropis. Ini yang saya sebut tadi, responnya tidak menganggap corona sebagai ancaman bagi bangsa Indonesia. Demikian juga kalau kita lihat berbagai kebijakan yang dikeluarkan oleh pemerintah. Hanya satu atau tidak begitu banyak peraturan yang merespon fenomena adanya corona ini sebagai ancaman, bahkan kemudian mencoba memanfaatkan kondisi ini untuk memperoleh keuntungan ekonomi. Kebijakan-kebijakan yang dikeluarkan adalah mencoba untuk mencari keuntungan dari peristiwa yang terjadi. Terus Mas, selanjutnya. Ini bisa kita lihat, kasus post-truth itu bisa terlihat jelas di kasus pertama ini. Pemerintah dengan demikian eksploitatif mencoba menyebarkan informasi kepada masyarakat bahwa kasus corona di Indonesia sudah bisa diatasi, di mana 3 pasien pertama dinyatakan sembuh, tidak pernah mendengar kabar bagaimana sebenarnya keberadaan dari 3 orang yang dinyatakan sebagai penderita terkena virus corona di masa-masa awal. Next, Mas. Nah, jadi pada saat ini sebenarnya dunia sebelum adanya fenomena post-truth ini dihadapkan pada sebuah pilihan untuk memberikan informasi tentang kebenaran atau tentang kebohongan. Seseorang yang berbicara benar maupun berbicara bohong adalah orang-orang yang masih memiliki moralitas. Kalau orang berbicara kebenaran, jelas moralnya adalah moralitas untuk menjunjung itu. Pembohong pun sebenarnya memiliki moral. Dia sebenarnya mengakui adanya kebenaran, tetapi kemudian mencoba mengingkari kebenaran itu dengan membuat pernyataan yang bertentangan dengan apa yang sebenarnya. Orang berbohong adalah orang yang sebenarnya juga mengakui kebenaran, tapi kemudian mencoba untuk memberikan informasi yang sebaliknya dari kebenaran itu. Nah, persoalannya kemudian di era post-truth yang kita hadapi bukan hanya 2 pilihan ini. Next, Mas, klik. Tetapi kita sedang menghadapi bullshitter, pembual dan omong kosong. Ini sama sekali berbeda. Pembual dan omong kosong itu adalah orang-orang yang tidak memperhatikan moralitas. Bagi mereka, benar atau tidak memiliki nilai. Jadi nilai-nilai sudah digeser, tidak lagi bersifat relatif, tapi juga sudah dinihilkan. Pada saat ini, setiap orang yang mendengar orang sedang membual di era ini, seringkali di perasaannya merasa bahwa ini sebuah yang belum tentu benar. Tetapi kemudian sebagian orang merasa tidak sopan untuk menyatakan bahwa apa yang dinyatakan itu sebagai sesuatu yang tidak benar. Jadi ada penjara eufemisme, pembual-pembual ini memperoleh panggung di masyarakat. Kan informasi tanpa didasarkan pada fakta yang selanjutnya akan menyebabkan orang menjadi tidak lagi peduli tentang kebenaran dan kebohongan. Munculnya para bullshitter ini diawali dengan adanya kebebasan berpendapat. Next, Mas. Langsung diklik saja semuanya. Yang bisa saja terjadi karena adanya keinginan sesaat, pencarian sensasi, maupun kepentingan-kepentingan yang lebih besar, baik kepentingan politik, kepentingan ekonomi, dan sebagainya. Yang mereka informasikan adalah informasi berupa pengetahuan, jadi bukan informasi yang berasal dari ilmu pengetahuan. Informasi yang berupa fakta dan kemudian diolah berdasarkan common sense saja, tidak menggunakan metode ilmiah. Dan informasi-informasi yang near faktual, informasi-informasi yang tidak merujuk pada fakta-fakta empiris. Inilah yang menyebabkan informasi yang disebarkan dan apa yang ditangkap oleh orang tentang kebenaran dan kebohongan, tetapi mereka memberikan informasi yang tidak merujuk pada fakta dengan tujuan agar orang yang menerima informasi berada dalam posisi mengalami kesalahan persepsi terhadap apa yang diinformasikan. Ada misrepresentasi dari orang yang memperoleh informasi, sehingga dia akan membuat respon-respon yang sesuai dengan apa yang diinginkan oleh pemberi informasi. Informasi ini diproduksi, direproduksi, disebarluaskan, terutama untuk menonjolkan keunggulan-keunggulan diri atau keburukan orang lain, baik dari persoalan-persoalan sara, sosial, politik, ekonomi, budaya, dan seterusnya, dengan klaim atau legitimasi bahwa yang mereka kemukakan adalah sebagai sebuah kebenaran alternatif atau kebenaran yang tentu tidak tahu kapan kebenaran itu akan realisasi karena memang itu hanya ada di dunia ide mereka. Nah, tujuan akhir dari pemberian informasi ini adalah untuk menggugah emosi, kemarahan, dan kebencian, dan adanya pemihakan dari kelompok-kelompok yang bersifat non-rasional. Next. Terus, Mas, terus. Oke, terus. Terus. Nah, oke, saat ini fakta empiris itu kalahkan dengan bukan fakta atau bahkan fiksi. Fakta dan data pada emosi dan keyakinan pribadi bentuk opini sebagai realitas alternatif. Jadi mereka menyatakan masih fakta itu adalah mencoba untuk menjadikan informasi yang tidak didasarkan fakta itu sebagai pengganti dari realitas yang merujuk pada fakta empiris. Post-truth bagaimanapun pada akhirnya akan menggoyahkan keberadaan dan daya mengikat hukum serta kemampuan untuk menghadirkan keadilan. Ini adalah keadilan adalah term yang menjadi aksiologi dari mazhab positivistik atau berbagai macam filsafat hukum, dan menghadirkan kebaikan sebagai salah satu ikon dari gerakan pemikiran profetik. Dengan ini, maka berbagai hal perlu dilakukan pemeriksaan ulang terhadap kebenaran karena orang mulai melakukan fakta, mulai melakukan realitas, mulai melakukan legalitas, kebenaran, dan seterusnya. Next. Oke, kita akan lihat bagaimana kebenaran di era post-truth. Next. Next, langsung diklik-klik saja semuanya. Nah, orang dalam kehidupan modern sebenarnya terpilah menjadi dua kelompok, yaitu orang-orang yang meyakini bukti empiris dan merujuk pada keyakinan personal. Ini saya akan berbicara bagaimana awal mula munculnya post-truth. Apa yang menjadi dasar filosofinya secara ontologi sehingga muncul post-truth. Jadi sekali lagi, dunia modern itu dipilah menjadi dua, yaitu yang merujuk pada evidence, bukti-bukti empiris, dan keyakinan-keyakinan personal. Nah, dari adanya dua titik ekstrim yang menjadi sumber ketegangan dalam menentukan mana yang menjadi sumber kebenaran, dunia modern dengan lokomotifnya filsafat positivistik telah sampai pada puncak kemenangan yang meyakini bahwa fakta itu sebagai sebuah kenyataan final. Jadi, untuk bisa menghasilkan kebenaran, maka harus merujuk pada fakta-fakta yang ada di dunia atau realitas empiris. Apa yang dijadikan keberhasilan dari dunia modern ini, di satu sisi merupakan penolakan terhadap keberadaan realitas metafisik yang bersifat transendental, yaitu sesuatu yang berada di luar kekuasaan manusia yang tidak bisa dijangkau oleh rasio manusia, dengan mengukuhkan evidence sebagai dasar-dasar untuk memperoleh kebenaran di satu sisi. Di sisi lain, ini juga merupakan perlawanan terhadap realitas ideal yang meyakini bahwa sumber kebenaran adalah keyakinan-keyakinan personal. Nah, justru sekarang yang menjadi dasar dari munculnya post-truth adalah mencoba untuk samping ganggu kebenaran-kebenaran akan empiris sebagai kenyataan final itu mulai diganggu melalui opini-opini yang kemudian diukur pada jiwa dunia manusia. Dan kebenaran didasarkan pada kesepakatan intersubjektif. Kebenaran tidak lagi merujuk pada fakta yang objektif, tapi berdasarkan pada kesepakatan intersubjektif. Pendapat yang seperti ini merujuk pada apa yang dikemukakan oleh Nietzsche sebagai salah satu tokoh dari filsafat perspektivisme. Inilah yang menjadi dasar dari munculnya keberadaan era post-truth. Sekali lagi, era post-truth ini mencoba mengganggu fakta melalui opini dengan tujuan akan ada kesangsian terhadap fakta. Jadi era ini mencoba mengganggu tentang keberadaan fakta agar orang tidak lagi memperhatikan fakta dan kemudian hanya berkutat di opini-opini yang tidak merujuk pada realitas empiris dan menjadi sulit untuk menjadi dasar adanya kebenaran. Sebagian orang yang mengumpulkan informasi dengan menggunakan retorika misalnya, dia hanya mengedepankan etos, adanya integritas orang yang berbicara dan patos, yaitu pembicaraannya itu mencoba untuk menggugah suasana batin atau keadaan emosional dari orang yang menerima informasi, tetapi mengorbankan atau tidak memperhatikan logos. Jadi para retoris, orang-orang yang beretorika itu hanya mencoba untuk memperhatikan dua hal, yaitu etos dan patos, memperhatikan bagaimana kredibilitas dan bagaimana dia bisa mempengaruhi orang yang diajak bicara, tetapi tidak perhatikan fakta-fakta yang menjadi dasar dari apa yang dia bicarakan. Next. Oke. Selanjutnya, era post-truth adalah era posmo. Gitu. Jadi kalau di dalam dunia modern adalah keberhasilan untuk menciptakan manusia-manusia rasional. Manusia-manusia rasional adalah manusia-manusia yang bisa memilah dunia ke dalam 3 kelompok besar, yaitu dunia objektif, dunia alam, dunia intersubjektif, dunia hubungan antar manusia, dan dunia subjektif, dunia personal. Nah, apa yang menjadi puncak keberhasilan dunia modern sebagaimana dikemukakan oleh Habermas itu, di mana manusia yang rasional adalah manusia yang bisa memilah mana yang masuk ke dunia objektif, dunia intersubjektif, dan dunia subjektif. Ini yang dicoba digugat oleh para pemikir-pemikir di era posmo seperti Nietzsche melalui filsafat perspektivismenya.
Recording in progress.
Menurut Nietzsche, dunia tidak terbagi menjadi 3, tapi hanya terbagi menjadi 2, yaitu dunia intersubjektif dan dunia subjektif. Dunia tempat di mana masyarakat berada, dan dunia di mana tempat manusia-manusia secara individu hidup. Belum, Mas? Masih? Oke, bentar. Sehingga Nietzsche atau para penganut filsafat perspektivisme ini tidak lagi mengakui keberadaan dunia objektif. Mereka mencoba mengganti keberadaan alam semesta ini dengan eksistensi lain, yaitu teks. Bagi mereka, semua pernyataan yang telah keluar dari subjek dan kemudian menjadi teks, itu memiliki otonomi dan memiliki eksistensinya sendiri, yang terlepas dari orang yang melahirkan teks. Jadi teks bersifat otonom, dia diakui sebagai subjek yang bisa hidup, dan kemudian mempengaruhi perilaku orang. Dengan demikian, tidak ada lagi pengetahuan objek yang berkorespondensi dengan fakta. Karena menurut para filosof perspektivisme, tidak akan pernah ada kesesuaian pernyataan dengan kenyataan. Kebenaran itu akan ditentukan dari bahasa dan merupakan hasil konstruksi kesadaran individu atau antar individu. Dan pada akhirnya, kebenaran merupakan hasil interpretasi atau merupakan hasil diskursus dari kekuasaan. Dan ini yang kemudian menjadi dasar dan akan semakin berkembang dengan cepat di era komunikasi digital melalui media sosial. Next. Saya lewati saja, Mas, agak cepat. Ini adalah teori-teori kebenaran. Sekilas, Mas, coba sebelum nanti kita berangkat masuk. Saya mencoba untuk menjelaskan untuk kebenaran di dalam ilmu ada merujuk pada 3 teori, yaitu teori kebenaran koherensi. Sesuatu dianggap benar apabila berkoherensi dengan pernyataan-pernyataan sebelumnya. Jadi setiap pernyataan yang konsisten dan runtut dengan pernyataan yang ada sebelumnya itu adalah benar. Sedangkan teori kebenaran korespondensi, sesuatu dianggap benar apabila tervalidasi dengan realitas empiris. Dan terakhir ada teori kebenaran pragmatisme yang bersifat relativisme. Sesuatu dianggap benar apabila bermanfaat bagi masyarakat. Nah, sekarang bagaimana kebenaran hukum? Next. Oke, kebenaran hukum menurut sebagian sarjana bukanlah kebenaran yang merujuk pada teori kebenaran koherensi, korespondensi, dan pragmatisme, tetapi teori yang merujuk kebenaran dalam hukum merupakan sebuah kebenaran normatif, sebuah kebenaran yang memiliki standar. Nah, normatif di dalam hukum bisa diukur dalam 2 aspek, yaitu kebenaran ketika menentukan norma hukum yang berlaku, dan kebenaran dalam menentukan siapa yang harus bertanggung jawab. Untuk bisa memperoleh kebenaran normatif, setiap pengembang hukum teoritis dan praktis, baik ilmuwan dan orang-orang profesional di bidang hukum, harus memiliki kemampuan untuk mengubah fakta-fakta empiris yang berupa desain menjadi terminologi normatif. Jadi di sini pengembangan hukum teoritis itu harus mampu memberi makna normatif terhadap realitas empiris. untuk bisa memberi makna normatif terhadap realitas empiris, maka pencarian kebenaran dalam hukum tidak lagi ditentukan oleh sesuatu yang berada di luar manusia, tetapi akan dipengaruhi oleh bahasa yang digunakan, atribut-atribut yang melekat pada pengembangan hukum, tingkat pendidikan akan diperoleh akan sangat bersifat subjektif dan meskipun berada dalam kerangka pemikiran hukum. Next, Mat. Diklik 2 kali, Mat. Oleh karena itu, kebenaran normatif sebagai sebuah terminologi dalam kebenaran hukum itu bersifat kontingen dan temporal dan tidak bersifat final karena dia akan terus berkembang sesuai dengan perkembangan masyarakat dan hukum yang ada. Next. Nah, sekarang bagaimana kita menemukan kebenaran di era post-truth? Hukum ini merupakan sebuah sistem objektif yang dapat menjadi acuan perilaku dari mereka yang tunduk di bawah. Keberadaan hukum pada dasarnya didukung oleh moralitas. Hanya saja moralitas seperti apa yang mendukung hukum ini menjadi beragam. Ada yang merujuk pada moralitas absolut, sebagaimana yang dirujuk para filosof di mazhab filsafat hukum kodrat. Ada juga yang merujuk pada moralitas relatif, seperti yang dirujuk para filosof di mazhab sejarah, pragmatic legal realism, dan sociological jurisprudence. Demikian juga para filosof di mazhab positivistik, merujuk pada moralitas yang bersifat relatif seperti itu. Nah, moralitas inilah sebenarnya yang kemudian menjadi dasar bagaimana hukum menjalankan fungsinya sebagai
Suara tidak terdengar, Prof.
Mohon maaf, sepertinya Prof Kelik ada kendala sinyal lagi, jadi keluar. Oke, sudah bergabung kembali.
Mohon maaf, terputus. Jadi bagaimana hukum menjadi terdengar ya, Pak Fahmi?
Ya, Prof.
Terdengar? Baik. Mohon maaf. Bagaimana hukum menjadi dasar untuk menentukan hukum dalam menjalankan fungsinya sebagai social control dan sebagai social engineering dengan mendukung fondasi utama dari hukum di era modern, yaitu rasionalitas. Dalam hal ini diharapkan hukum tidak saja digunakan untuk melindungi kepentingan diri mereka, tetapi juga melindungi kepentingan publik. Next. Nah, ini yang mau saya coba usulkan. Persoalan inilah yang kemudian sebenarnya menyebabkan munculnya postur di Indonesia, yaitu sumber moral. Kalau kita perhatikan, sumber moral di dalam hukum itu bisa dipilah menjadi 2 kelompok besar, yaitu hukum yang merujuk pada sumber moralitas Tuhan, yaitu moralitas yang bersifat absolut dan universal di satu sisi, dan hukum yang merujuk pada moralitas relatif, yang merujuk pada nilai-nilai yang tumbuh dan berkembang di masyarakat. Diklik, Mas, 2 kali. 2 kali. Nah, di samping 2 moral itu, ada satu moralitas lagi, yaitu moralitas normatif, ada di dalam peraturan perundang-undangan yang sebenarnya merupakan sebagai hasil dari konstruk berpikir dari manusia. Nah, di dalam perkembangannya, moralitas yang semula berasal dari Tuhan sebagai moralitas absolut ini kemudian beralih menjadi moralitas individu. Ini terutama dilakukan oleh para penguasa yang mencoba mencari legalitas dari Tuhan. Kita bisa mendengar bagaimana raja di masa-masa dulu menganggap sebagai perwakilan Tuhan di dunia karena mereka mencoba untuk mencari dasar hukum dari moralitas Tuhan sebagai legitimasi dari hukum-hukum yang dibuat. Itu di satu sisi. Di sisi lain, ada juga moralitas yang muncul dari nilai-nilai yang tumbuh dan berkembang di masyarakat dan kemudian menjadi sebuah moralitas yang relatif. Demikian juga dengan moralitas absolut. Dengan keberadaan moralitas normatif yang juga bersifat relatif. Nah, moralitas yang bersifat relatif inilah yang sebenarnya kemudian menyebabkan menjadi tumbuh suburnya kepala bursiter yang menyebarkan informasi-informasi yang tidak merujuk pada fakta-fakta empiris. Next. Selanjutnya terus. Nah, ini yang akan saya coba tawarkan. Ada model moralitas baru yang saya coba tawarkan, yaitu moralitas profetik sebagai sebuah moralitas dalam dunia normatif relatif yang berdialektik dengan dunia ide dan dunia empiris. Jadi moralitas profetik adalah moralitas yang ada dalam diri setiap individu, tetapi itu merupakan hasil internalisasi dari moralitas Tuhan, yaitu dari sumber utamanya, wahyu, yang kemudian tertafsir oleh manusia yang berakal, serta telah terverifikasi dengan moralitas masyarakat. Jadi bagaimanapun harus kita sadari dalam diri individu yang terinternalisasi bukan hanya nilai-nilai yang berasal dari ajaran agama, tapi juga nilai-nilai yang berasal dari masyarakat di mana individu itu hidup. Dan inilah yang diharapkan menjadi sumber moralitas individu. Next.
Tes.
Ya, mohon maaf, Prof. Kelik sepertinya ada kendala lagi. Tadi jaringannya barusan saya coba cek masih mencoba untuk menyambung. Baik, mohon maaf. Sepertinya Prof. Kelik sudah sulit lagi terhubung karena kendala sinyal. I apologize for not being able to continue. Yeah, I want to try to recap the material from Prof. Kelik regarding Prof. Kelik already explained to us regarding the law in the post-truth era. How do we need to restructure and develop our law? And it was also discussed regarding the bullshitters as well as examples of what government officials say and their policies back in the pandemic era. In the past, there were only two possibilities: the truth and lies. But now there is one more entity, namely a statement that may not be true, but it is disrespectful if it is said to be wrong. It has also been discussed about why there is something called post-truth from its ontology and epistemology. Given these things, it becomes very important how we can find the truth, or we can find the legal truth in the post-truth era, and we can base it on the prophetic morality as explained from before. So I would like to say thank you to Prof. Kelik, and I would like to convey to the participant that Prof. Kelik sent his apologies to all of us because he cannot continue, and I would like to express my deepest gratitude to Prof. Kelik Wardiono for taking time today and willing to join us in ICRT LAW. So I think we can move to the second session. If you have any question, we will open the Q&A session after the third session. So now we move to the second presentation session. The second speaker will be Dr. Husna Sarirah binti Husin. Good morning, Dr. Husna.
Good morning. Assalamualaikum.
Waalaikumsalam. Before we start the presentation, I'd like to read a brief introduction to our speaker. Currently, Dr. Husna is a lecturer in the Information System Department at Universiti Kuala Lumpur, Malaysian Institute of Information Technology, or UNIKL. She received a Master in Information System from UITM, and before she joined UNIKL, she worked as programmer in an STP Berhad and as system analyst in Kementerian Sumber Asli dan Alam Sekitar in Malaysia. And she has published a number of papers in conference, and some of her most recent publications are entitled Process Mining to Discover Online Learning Behavior and Exploring Process Mining for Analyzing User Navigation Behavior. Okay. So without any further ado, let's begin the presentation session from Dr. Husna. Okay, Dr. Husna, time is yours.
Yeah, thank you, Mr. Fahmi. Assalamualaikum and good morning, everyone. First of all, I would like to share my appreciation and thanks for inviting me for your conference today. And thank you to Mr. Fahmi, thank you to Dr. Arif, Wardiono, and also the committee of the conference. Thank you to Faculty of Law in MS for inviting me as well. And I hope you can enjoy my presentation. So like what was mentioned by Mr. Fahmi, I'm a lecturer in IT, so I'm not very fluent in law, but my sharing today is on protecting data privacy in Malaysia. So basically on how Malaysia has taken some effort or initiative in protecting the data privacy. Okay, so let's begin now. Bismillahirrahmanirrahim. Okay, so this is UNIKL. This is my office here. So we are the tallest university in Malaysia. Okay, so if you come over to KL, feel free to reach out to me. So maybe I can bring you around in KL. So we have 12 campuses in Malaysia, and each campus is is for every area. So for me, it's IT in KL. Okay, so let's begin. Bismillah. Okay, so you know, like what Prof Kelik mentioned before, after pandemic, and there's a lot of post-truths happen going around. So as you know, internet is ubiquitous, it's everywhere. Okay, so even now we are communicating through Zoom using internet, using Wi-Fi, and the technology has advanced so quickly in the past 10 years. So in the past 10 years, you can see so many advancements, especially in mobile applications, in social media, and anyone can now access practically to anything, including other people's personal information. Okay, and the internet now is not just for connecting people and doing research, but it has evolved to a platform where many people can store information and promote themselves and their businesses. So I'm sure each one of you has a social media account like Facebook, Instagram, TikTok. So those are the platforms or the medium where you can promote yourself and also promote your businesses as well. Okay, in Malaysia, we do not have a special law such as Privacy Act to safeguard individual privacy, but we have this Personal Data Protection Act 2010, or what we call as PDPA. So this law was introduced to deal with personal data and is focused on regulating the processing of personal data in business transactions. So it is not specifically for privacy, but it deals with personal data, especially in business transactions. Okay, so before we go into more deeply about PDPA, so I would want to tell you why privacy rights are important. Okay, the first one here, this was taken from the website here at the bottom. You can see the link. Okay, so according to this website, the first reason why privacy rights are important is to prevent the government from spying on people without cause. So I'm sure you have heard about the case Edward Snowden, when he revealed that NSA, the agency in US, has get all the data of their citizens. Okay, so it was a big issue, and I think he's still on the run now somewhere other countries out of US. Okay, and the second reason is to ensure that we want to keep the groups from using personal data for their own goals. Okay, so when the wrong hands, personal information can be wielded as a powerful tool Okay, so one example, if you have heard of this scandal called Cambridge Analytica scandal, this organization, they use data taken from Facebook without the user consent to influence voters with political ads. Okay, so the privacy right mean the group cannot take data without your consent because they are using the data without the user's consent and for their own personal goal. Okay, the next one is to ensure those who are stealing or misusing data are held accountable. Okay, so when the privacy is recognized as a basic human right, there are consequences for those who disrespect it. So while there are many soft examples of personal data use like targeted ads, established privacy rights will draw the line or the border clearly. Okay, so without these restrictions, corporations and also governments may likely to steal and misuse data without consequences. That's why the privacy law is necessary for the protection of privacy rights of the users and also the data itself. Okay, there's actually 10 reasons. Okay, so the first reason is to help maintain social boundaries. Okay, so everyone has things that they don't want everybody to know. Okay, so having the right into establishing these boundaries is important for healthy relationships and also careers especially. So in the past, putting out boundaries meaning you do not talk about your specific topics. But today, any amount of personal information can easily be found on the internet. Okay, so social media can reveal a lot of information that we don't want certain people or strangers to know. So media platforms are obligated to offer security features. So having control of who knows what gives us the peace of mind. Okay, the next one is, of course, to build trust. Okay, so build in every relationship, in family, in friends, colleagues, between lecturers and students, you need to build trust because trust is essential. So when it comes to the personal data given to doctor or bank, so you trust them to make sure that your data is properly safeguarded and also are not spread out easily. Okay, at the bottom here is the next one. Number 6 is to ensure that we have control over our data. So that is your data, so you should have control over it, such as your name, your ID number, your bank account. Okay, so privacy rights will dictate that your data can only be used in the ways that you agree to it. Okay, and here is to protect the freedom of speech and thought. Okay, so if privacy rights are not established, everything you do could be monitored. Even whatever you say or whatever your thoughts can be misconstrued, and also you might get some problems with it, even though you just thought about it or just talk about it, like just talk with your friends. Okay, next one is to let you engage freely in politics. Okay, so here there's a reason when you do your voting, it is done in secret. You're not supposed to tell everybody who you vote for. Okay, so you're also not required to tell anybody who is the one that you chose in your votes. Okay, so privacy rights let you follow your own opinion on politics without anyone else seeing. And then also to protect reputation. So if you have done something that you regretted in the past or something foolishly, so it can come back to haunt you or to embarrass you in some ways. So privacy rights can help to protect us and also give us the power to get certain information removed. Okay, and lastly is to protect your finances. Okay, so companies that store data, especially banks, okay, should protect the information because if they fail to do so, you may lose your money or you may lose your investment. Okay, so let's proceed with PDPA. So PDPA is Personal Data Protection Act 2010. So it's an act in Malaysia that regulates the processing of personal data in regards to commercial transaction. So this act specifically focuses on personal data that is used in commercial transaction. So this act applies to any person who collects and processes the personal data that is regards to commercial transaction and was gazetted in June 2010. So the penalty for non-compliance is between 100K to 500K or between 1 to 3 years imprisonment. So I'm not sure how much is this value converted to Indonesian rupiah. Okay, so who must comply with this Personal Data Protection Act? So all individuals and organizations that process personal data in their dealings must comply with the rules set out in the Personal Data Protection Act, except for the federal government and also the state government. So in Malaysia, we have federal government, which is the government, and because we have 14 different states, we also have the state's government as well. So what kind of data that are being protected by PDPA? So any information or data or a chain of information that allows a person, a living individual, to be identified are covered under PDPA. So here are some examples. So this is an icon of Malaysian identity card. So this is how our identity card looks like. Okay, so we have our photo and this is the number of our My Card. We call it My Card with the name and also address. So this information is protected under PDPA. The name and address, your ID number, okay, your passport number, any health information stored in the hospitals, in the clinics. Okay, even email addresses is also data protected because you don't want to get all those spam emails or junk emails from don't know who, okay, from Prince of Nigeria asking for money and so whatnot. And then pictures, okay, pictures are images recorded by CCTV and also information contained in personal files. For example, in the university, I'm sure you do give out your personal information to the university office, or if you are working, you will give it out to your HR department. So all these data are protected by PDPA. So what does an organization process the personal data? So the organization must comply with the act only if the organization is processing this personal data. So these examples of activities can be considered as collecting data through forms, by phone or via the web. Okay, for example, if you go to the shopping mall, they said they are having some kind of competition and you have to fill up form. And then if you are the lucky winner, they will choose your name and you will win. So that is also activities considered as processing. Okay, publishing data, if you publish your data online or even on the print. Okay, selling data, this is also processing activities. Using administrative data, using data for marketing purposes, recording data, okay, disclosing or providing data to other organizations, as well as destroying data. So there must be proper ways on how you want to do all these activities that deals with your data. So who are the classes of data users that have to register under PDPA? So communications, okay, banking and financial institution, insurance company, health providers, hospitals, clinics, okay, tourism and hospitalities, the hotels, transportation services, education like universities, okay, direct selling services, real estate, utilities, pawnbroker, and also money lender as well. So what is not protected by PDPA 2010 is, like what I've mentioned earlier, data which is processed by federal and state government, data solely and wholly processed outside Malaysia, okay, data processed in non-commercial transactions, okay, data processed for credit reporting business, and also data processed by individual for the purpose of the individual's personal, family, or household affairs. Okay, so here are the 7 guides for the PDPA for the data users. first one is the general principle of consent. Okay, so in this section, you have to get consent or permission from the users before you process the data. The second one is notice and choice, where you have to give a written notice to your data subject, informing the details such as the description of the data, the purpose of the data, okay, the sources, the right to request access, and so on. Okay, and the third one is disclosure. This one. Okay, so here is notice and choice. Then the third one is disclosure. Okay, so here you have to ask for the data subject's consent if the personal data is to be disclosed for any other purpose other than the purpose for which the personal data was to be disclosed at the time of collection. Okay, and then security principles, you have to take practical steps to ensure data is protected from any laws such as cybersecurity attack. Okay, and then retention principle is where you have to inform the data to ensure that the personal data is not kept longer than necessary, and to take all reasonable steps to ensure that all personal data is permanently deleted or destroyed if it's no longer required. Okay, the sixth one is data integrity or principle, where you have to take reasonable steps to ensure that the personal data is accurate, complete, and not misleading, and also keep up to date. And finally is the access principle. Okay, so here you allow the data subject to access to their personal data and to be able to correct if there's any inaccuracies, any incompleteness, misleading, or not up-to-date personal data. Okay, so here are the list of the rights granted by the PDPA to the subject or the people. Okay, the right to be told whether their data is processed by an organization, the right to access personal data, to rectify, to withdraw consent, to prevent processing that likely to cause damage or distress, and also to prevent processing for purposes of direct marketing. Okay, as a user, personally, I think usually they always miss out the fourth one, which is to the right to withdraw consent. Okay, for example, if you subscribe to a service, you have this very long-winded thing that you have to agree for. Okay, but once, let's say, you want to withdraw your subscription, you always cannot find the unsubscribe button. Okay, this number 4 is always missing in most of the applications lah. Okay, so how does PDPA affect business? Because PDPA deals with the data that you have to process under commercial transaction. Okay, so personal data are directly related to your data subject, which is your personal information, or the personal data is where the data is processed outsourced to a third party known as the data processor. Okay, so this is the responsibility of the data user to ensure that the data processor provides sufficient guarantee to protect the personal data from any loss, misuse, modification, unauthorized or accidental access, or disclosure, alteration, or distraction. So if you want to open a business in Malaysia and you are dealing with data that you are going to use for your commercial transaction, so what do you have to do to make sure you meet the requirement of PDPA? So the first one is to get the express consent from the users before processing any data from them. Okay, and then you have to communicate to data subjects or the users what kind of data that you are collecting on them. And then you have to maintain a proper channels of communication to allow the users or the data subject to request access, alteration, or deletion of data collected on them. Okay, and you must have a robust structure of data mapping within your organization. And finally, you have to properly educate your employees and your workforce on your data processing methods to reduce the chance of any discrepancies. So for the businesses, one of the challenges, because this PDPA Act affect the personal data lifecycle process from the point where you collect your data, you use the data, you store the data until you destroy the data. So this Act applies to customers, employees, and also third-party service providers of personal data. So the company's way of doing business will definitely be affected as business processes are required to be refined to comply with PDPA requirements. So what you can do is to have a central repository for consent management. So the process will become more complex when cross-border personal data transfer is involved. Okay, so if you ask me, so this act was gazetted in 2010, now it's already 2023. Has there been any enforcement of PDPA? Yes, I have found some cases here, okay, quite recent in 2017 by this hotel. Okay, so the offense was processing personal data without certification or registration and also without consent. Okay, and then the second case was by a private higher education institution, a university, where they also process personal data without certificate or registration. And the third one is by an employment agency. So the imprisonment may be applicable to any director or officer of these three entities unless they are able to prove that offense was committed without his or her knowledge, consent, or connivance, and they have taken all reasonable precautions and exercised due diligence to prevent the commission of the offense. Okay, so besides PDPA, in Malaysia, they also have other related statutes or laws or acts on privacy. So another one here is a provision of offensive content. So this one was in sections 211 and 223 of the Communications and Multimedia Act 1998 or CMA. So it prohibits the provision of offensive content, which is indecent, obscene, false, or menacing with the intent to annoy, abuse, threaten, or harass any person. Okay, however, these two sections, 211 and 233, are not specifically about the right to privacy and very broad to describe the offensive content on the internet. And it is also subject to the court's assessment whether the content can fall under the types of offensive content. Another statute is in section 509 of the Penal Code. It's a criminal offense to intrude upon the privacy of a person. However, this strictly applies to actions which insult the modesty of a person. So upon conviction, an offender may be punished with imprisonment for a term which may extend to 5 years or with fine or with both. Okay, so I have talked about PDPA in Malaysia. So now I will compare about PDPA, and here is GDPR. Okay, GDPR, General Data Protection Regulation, which is applied in EU, in European Union. Okay, so you can see the Malaysian principles are the 7 principles that I have mentioned earlier, and also these are the one from GDPR. So GDPR principles, they talk about lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity, and accountability. So basically, the principles are quite similar between GDPR and Malaysian principles as well. And here are the list of privacy laws in Asia and Australia. So they have it in Hong Kong, in China, in Taiwan, in Singapore, in Philippines, in Thailand, Vietnam, Japan, South Korea, Australia, and New Zealand. And I know that in Indonesia as well, you have also come up with a protection of personal data that came in force in 2022, if I'm not mistaken. Okay, so it will add into this list of the privacy laws in Asia. And here are the overview of the global data privacy regulations all over the world. So we have it also in Canada, in US, in Brazil, Argentina, Turkey, Russia, South Korea. So everywhere in all over the world, you have to make sure that your privacy is protected. So in conclusion, Malaysia has a distinction of being one of the few nations that have taken early steps or initiative in defending the citizens' online privacy and digital rights through PDPA. Okay, so in PDPA, Malaysian residents have the control over how internet businesses and websites collect, use, share, and also destroy their personal data. And PDPA goes into great detail about the rights that a consumer has in relation to the collection of their data as well. So it's regarded as a well-balanced piece of legislation to ensure the rights to privacy. Okay, so that's the end of my presentation. So if you have any questions, please feel free to ask any questions. And I hope you enjoy the presentation and also learn something from it. Okay, thank you.
Okay, thank you so much, Dr. Husna,
Welcome.
for the presentation. I think your presentation is really interesting, and I would like to try to recap some. Okay, so protection of personal data has recently become increasingly hot topic, I can say, both nationally and globally. Also in Indonesia, yeah. Dr. Husna has talked about how personal data is protected in Malaysia and the reasons why privacy rights are important, such as preventing the government from spying on people, which is, we often discuss it publicly, how the government can see our data, our personal data. And maybe the other example is, okay, sorry. Can you hear me?
Yeah, I can hear you.
Okay, sorry. My signal is not unstable. Okay, I will repeat some. Yeah, Dr. Husna already talk about the reason why it is very important to protect our personal data. And the second is how we need to keep groups from using personal data for their own goods. For example, that maybe the recent case is come from the US, and they try to confront with the TikTok CEO. Maybe we all know about that. And also maybe a few times ago regarding the Facebook, if we say something, then the advertisement show up in our social media and etc. It's I think we have to concern about this. And the last, maybe I would like to give some example regarding the we need to protect our finances. In Indonesia, recently we have this case regarding PSI or Bank Syariah Indonesia, where there were rumors the stolen consumer data for sale on the dark web. I think it's really dangerous. And the next is Malaysia already has regulations regarding the personal data protection since 2010, as stipulated in the Personal Data Protection Act, or PDPA, which is an act that regulates the process or the processing of personal data in regards to commercial transactions. Also mentioned before, Indonesia itself, we also have the regulation in 2022, namely the law number 27 of 2002 concerning personal data protection. Okay, so Dr. Husna, maybe we need to wait for the Q&A session. We will have to wait until the last presenter present her material. So before we move to the next presenter, I would like to say thank you, Dr. Husna, for taking time today and willing to joining us in
Thank
ICRT
you.
LAW. But we also hope Dr. Husna can stay in the Zoom meeting because later we will have the Q&A session.
Yes, I will stay in the meeting. Okay, thank you.
Okay, thank you, Dr. Husna.
See you.
Okay, we move to the next session. The third speaker will be Prof. Yusramizza binti Muhammadiyah. Prof. Yusramizza, are you already joining us in the Zoom meeting? Prof. Yusramizza.
Assalamualaikum warahmatullahi wabarakatuh. Very good morning. Can you hear my voice?
Yes, Prof.
All right.
Yusramizza.
Yeah.
Okay.
So I will be sharing the slide, or the
Yeah.
community member will be sharing.
Would you like to share
It's
by
all right.
yourself, or you need to
It's
help from us?
right. I will be sharing.
Okay.
Wait for
Okay.
me.
Before we start the presentation, I'd like to read a brief introduction to our speaker, Prof. Yusramizza. Prof. Yusramizza is a professor and currently at the Dean of School of Law, College of Law, Government and International Studies, or Polkis, Universiti Utara, Malaysia. She was also the Deputy Legal Advisor for UUM. She graduated from International Islamic University Malaysia, IUM, with a Bachelor of Law with honors, and obtained a Master of Laws from Universiti Kebangsaan Malaysia, or UKM. And also, Prof. Yusramizza obtained a PhD in law without correction from the prestigious Lancaster University, United Kingdom, in 2016. As specializing in drug policy and law, as well as relevant criminal justice and public health approaches. She is also a qualified advocate and solicitor and had experiences as a practicing lawyer. Her research interests include criminal law, criminology, public health law, drug law, and policy. She is also active as the editor of renowned international index journals, including Scopus Journal in many countries, also in UUM, including the United Kingdom, United States, Singapore, and India. Today, Prof. Yusramizza will talk about cybercrimes and the trends and challenges. So without any further ado, let's begin the presentation session. Prof. Yusramizza, time is yours.
All right. Thank you very much, the chairperson. Assalamualaikum warahmatullahi wabarakatuh. Very good morning. So this is the topic of my presentation: cybercrimes, trends, and challenges. So I will be presenting the important point relating to the modern development of these cybercrimes, and we are trying our best to propose something that can be regarded as the practical approaches to address this rising cybercrime nowadays. So let's begin with the first slide. So I think it's very useful if we are going to refer to the definitions available pertaining to the cybercrime. So the common definition prescribed for this cybercrime is any activity in which computers or networks are a tool, a target, or up to the context of the computers or networks or any context irrelevant to these particular devices that will be considered relevant and related to the criminal activities. While if we are referring to the specific definition, so for example, we can refer to the specific coverage of the provision relating to the each particular crime that can be considered as the cybercrime. So it can be regarded as the computer-mediated activities which are either illegal or considered illicit by certain parties and which can be conducted through global electronic networks. So this is the specific interpretations of the cybercrime that we can understand by looking at the general definitions of the cybercrime, but having considered the specific definitions of the cybercrime, we can refer directly and explicitly to the coverage of each particular section pertaining to the crime. All right, now we are going to relate some of the discussion relating to the initial or the setting of this cybercrime. So let's look at the nature and the history of cybercrimes. So cybercrime, if we are looking at the historical part, it can be considered in existence before Microsoft Windows, the internet, or the personal computer. So the first officially recognized cybercrime occurred in 1964 when MIT student, Massachusetts Institute of Technology student, used a MIT computer to generate the tones required to access long-distance phone service. So this cybercrime can be historically detected from or since 1964. It's very long too, that can be considered as the long journey before we can be tracking the existence of the recent cybercrime. So since 1964, there was the existence of the cybercrime. So cybercrime has become a significant international and national concern since then. And then with respect to the occurrence in Malaysia, the cybercrimes have also happened in Malaysia, particularly after 1987, in which internet was introduced in the country by the Malaysian Institute of Microelectronic System, which is called as MIMOS. So this is the general introduction relating to the history of the cybercrimes in the world and particularly in Malaysia. So I will be highlighting the important principle relating to the cybercrimes, the coverage of the nature, but at the same time, I would like to give some particular reference to the Malaysian context so that we can relate to the Asian context of these cybercrimes, or that can be considered as the cyberspace crimes. I would like to highlight now the scenario of the digital use in Malaysia so that we can understand the particular scenario of this important cyberspace and then its relation to the criminal activities that are very rampant and very significant to be addressed. With regard to the Malaysian context, so the usage of this cyberspace is very high. For instance, in 2018, it was estimated or projected 83 million of the Malaysians. There were 25.08 million of the internet users. Additionally, we can discover 21.62 million of the unique mobile users and 24.00 million or 24 million of the active social media users, while we can also trace 22 million active mobile social users. So we can conclude here that the usage of this cyberspace in Malaysia is very high. It is very clear that we have the rampant scenario with regard to the cyber or the digital usage in Malaysia. Let's go to this cartoon. So I have found this particular photo of the cartoon is very interesting actually. We can relate to the incident pertaining to the cyber crimes. For instance, in this particular photo, you can look at this particular stages of the ranking. Maybe it can be considered as the first floor regarding the addition with regard to the Facebook usage. And then the second floor is fulfilled by the Twitter usage. And then coming to the third floor, we can referring to the Instagram. So that this cartoon can reflect to us that there is the stages of the addiction that we regard to the usage of the internet or the cyberspace. Now, is beneficial, I tend to believe, if we are also to be exploring the scenario of the cyber crimes in Malaysia, so that I can share with you the scenario that we can relate with the existence of the criminal provisions at the same time the criminal sanction that has been prescribed for this particular scenario. Okay, we have the key statistic that we can rely as the indicator for the rampant scenario of the cyber crime. For instance, starting from 2015, there were 8,762 cases. And then there were also many cases or the abandoned cases in the subsequent years. And we can look at the progress of the high cases. The cases of the cyber crimes in Malaysia are growing significantly. The Royal Malaysian Police reported that there were averagely more than 10,000 cases every year starting from 2016. For example, in 2019, there were 11,875 cases, while in 2020, there were 40,229 cyber crimes. It's very interesting to have a look at this particular advancement in bracket comma. In 2022, there were more than 20,000 cases. Many parties, including the Bank Negara Malaysia of this can be considered as the National Bank of Malaysia, has disclosed this particular rampant cases involving the cyberspace. And we have the tremendous progress with regard to the cases. Is very shocking. So having considered the particular incidences of these cyber crimes, actually the cyber crimes that have happened in Malaysia can be consisting of these particular categories, particularly this cyber harassment. It can be inclusive of the cyberbullying, cyber stalking, and others. So it can be regarded under the term of the cyber harassment. So it has happened rapidly in Malaysia. And then we have also the category of the fraud and forgery. So this is one of the other serious cyber crimes happen rampantly in Malaysia that can be inclusive of this phishing, fraud transaction, online scam, and others. And we have also the other category of the cybercrime that has happened significantly in Malaysia, which is malicious code. It can be covering the malware, and we have also the denial of service, DOS, and then we have also the intrusions attempt. It can be covering of the spot scanning, and then we have also the category of the cybercrime of the spam misconfiguration, and it can be consisting of the disclosure. So all these categories of the cybercrimes are very significant and rampant in Malaysia. So these are the particular threat that we have to consider while we are looking at the relevant provisions relating to the cybercrimes. Okay, now I would like to share the samples of the cases which are very important to be noted while we are discussing about the Malaysian context. For instance, the first case that can be considered very interesting and the Malaysian Airlines website. So this news has attracted the world perspective with this particular incident, very significant incident involving the attacks on the Malaysian Airlines website by the Lizard Squad. This is the official cyber caliphate in January 2015. So the users who log onto the Malaysian Airlines website were greeted with the image of a lizard in a top hat and the message 404, plane not found. Below that were the words. So there is the one particular phrase stated or that can be appearing while the users accessing the website, hacked by Lizard Squad official cyber caliphate. So this is one of the important cases irrelevant to the cybercrime, which is the cyber attack to the website of the Malaysian Airlines. And then in 2017, there were also the attacks involving 3 government agency websites and 51 local small company websites. So there were the inventions of these websites covering the government agency and also the private agencies. And in similar year, we have discovered the case involving 77 credit card information of Malaysians has been revealed on the internet. And then we have also the particular important cybercrime or attack involving the phishing spear attack regarding the issue of MH370 of the Malaysian Airline. So in this particular case happening in 2018, it can be considered as the example of a successful spear phishing attack occurred in 2014 when around 30 computers at Malaysian law enforcement agencies, MH370 airplane were reportedly hacked with perpetrators making off with confidential data on the missing aircraft. And then the Asian News Network reported in 2014 that the computers of high-ranking officials in several Malaysian aviation and securities agencies were hacked, and this is particularly relevant to the classified information removal. The point of entry for the compromise was said to be spear phishing attack with a malicious excusable file in the format of a PDF file. when the attachment was with malware, allowing the hacker to gain access to their PC from outside and send stolen information back to an IP address in China. But this case cannot be considered that the cybercrime has been committed explicitly or directly by the China, because the hackers have utilized the IP address in China. All right, looking at the samples of the cases occurring in Malaysia involving the cyber crimes, now I would like to turn your attention to this particular aspect. Laws, measures and achievement, and also to be inclusive of these potentials in Malaysia, and also relevant to the approach in other countries. So the legal measures are very crucial for the prevention and the combating of the cybercrime. At the Malaysian level, the cybercrimes are most concern criminalization. So we emphasize on the criminalizations rather than the other approaches. At the same time, we can note the significant incident or the status involving the law in Malaysia. The laws are applicable to the monitoring, detection, prevention, mitigation, and the management of the incidents pertaining to the cyber crimes. And irrelevant to this particular point, we can also regard this particular approach very significant, and then the legal measures irrelevant to the philosophy of the criminalization contain an extensive list of offenses. And then the core Cybercrimes Act, which are very crucial and covered by the law in Malaysia, are criminalized using cyber-specific offense, meaning that there are certain cyber-specific offenses provided by the Malaysian law, while we are looking also to the other category of the general offenses prescribing and covering all these particular cyber crimes. So for instance, we have the category of the cyber or the computer-related acts involving, for example, the fraud, the forgery involving the information available in the website or in the computer. But at the same time, this category of the cyber crimes have been covered under the general category of the offenses, inclusive of the available Malaysian Penal Code and others. But looking at the first category of the offenses prescribed for this particular cybercrime related or oriented action, we can have the specific coverage of the offenses under the specific provision under the specific law for that particular cyber crimes. But we are also dependent on the other categories of the cyber crimes, which are generally covered by the available or the existing provisions in the available law in Malaysia. This is very important because we have these two categories of the statutes or the categories of the offenses under the provisions available in Malaysia, because we have no any single statute covering all the categories of the offenses. We have certain categories of the statutes enacted that can be considered relevant to the context of the cyber crimes. So we can learn cyber security law, but we have the number of laws in this area to counter the cyber crimes. So this include certain statute. For example, we have the Copyright Act 1987, the Computer Crimes Act 1997, and the Communications and Multimedia Act 1998. And we have also the Personal Data Protection Act 2010, and we have also the available Malaysian Penal Code. Maybe I would like to highlight some of the provisions enacted in Malaysia relevant to the context of the cybercrime. By way of illustration, the first category of the crimes related to the misuse of computers, it has been explicitly and importantly covered by the Computer Crimes Act 1997. We have certain categories of the offences, particularly hacking, cracking, and authorized modifications of the contents of any computer. And we have also the other category of the Act, Communications and Multimedia Act 1998. This is relevant to the context of the crime related to the communication and multimedia industries. So that we have the extensive provision relating to this category of the multimedia or the communication-based offences that can be inclusive of this content or offensive in character. We have also the category of the offence related to the improper use of network facilities or network service. We have also the crime relating to the possessions or use of hardware, software, or other tools used to commit the cybercrime. At the same time, we have also to note that we have the specific offense of the distribution or advertisement of any communications equipment or device for intersection of the communication. And we have also the other category, particular relevant provisions involving any other activity that adversely affects or threatens the security, confidentiality, integrity, or availability of any IT system, infrastructure, communications network, device, or data. And then, as I have mentioned, we have also the coverage of the offences irrelevant to the cyber crimes in the available penal code enacted in Malaysia. We have, for instance, the category of the spreading of the terrorist propaganda and phishing and criminal intimidation and harassment. So that by looking at the action involving this, for example, covered under section 503 pertaining to the criminal intimidation, so that any kinds of the behaviors that can be falling under the category of the criminal intimidation, whether it can be a physical or direct criminal intimidation, or it can be in terms of the online criminal intimidation, so it can be covered under the available provision related to this category of offense under the available Malaysian Penal Code. Similarly, we have also the specific statute relating to the Copyright Act 1987. So that this particular statute, even it is general, like we have discussed pertaining to the penal code, but we have the potentiality or the opportunity to invoke this particular general provision related to certain crime enacted under this category of the statute for the online behavior that can be falling under the offense listed under this Copyright Act 1987. For instance, we have section 36B. This is regarding the removal or alterations of any electronic rights, and it is to be involving the management information. And we have also the other range of offences for the copyright infringement. So any kinds of the copyright infringement committed through the online platform, so it can be covered under this section. For example, Section 41.
HP siya ako.
And then as well, if we are referring to the other specific statute, which is the Personal Data Protection Act 2010. So this statute can be utilized for covering certain offense involving the failure to protect the personal data from any loss, unauthorized or accidental access or disclosures, alteration or destruction. So it can be covered under this particular act. So any kinds of the failure or the negligence on the part of any individual or the company be covered and to be considered as the offense under this statute. And we have a range of the agencies and departments that are responsible for enforcing and handling all the statutes available in Malaysia with regard to these criminal behaviors involving the cyberspace. For example, we have the MCMC, Malaysian Communications and Multimedia Commission, and we have also the important agency, which is Royal Malaysian Police, and we have also the responsibility of the Bank Negara Malaysia, which is the Central Bank of Malaysia, and Commission Malaysia. So all these agencies are the important agencies involving in this enforcement and monitoring of the fulfillment of the statute irrelevant to the cybercrime in Malaysia. All right. Now, I would like to bring your particular attention and consideration to certain issues and challenges, not only to be considered related to the context of Malaysia, but it can be considered very significant and relevant to the context of many countries, including Indonesia and others. Okay, let's go to the first category of the issue. Challenges in drafting the national criminal laws. I believe that the proper legislation is the foundation for the investigation and prosecutions of the cyber crimes. However, the lawmakers must continuously respond to the internet developments and monitor the efficacy and the effectiveness of existing provisions, especially given the speed of developments in network technology. So this is the particular important point to be considered and to be adopted with regard to the proper legislation in many countries. So we have to ensure that the initiative with respect to the legislation in order to address the cybercrime must constantly respond to the internet development. So we cannot just enact the law and promulgate certain legislation in order to be considered relevant to the context of the cybercrime, but we have not checked the suitability and also the efficacy of this particular legislation irrelevant or in the compatibility with the recent development in the internet of things. And then we have to note here that the main challenge for the national criminal legal system is the delay between the recognition of the potential abuses of the new technologies and the necessary amendments to the national criminal law. So many countries, including Malaysia, and it can be potentially including Indonesia and many other nations, are working hard to catch up with the legislative adjustment. However, the issues remain, including by way of illustration, complicated standardization of the regulation across to note that there is the absence of any specific law. So every law will be having the limited scope, and it still requires other supplementary laws. So this is the significant challenge that should be addressed by many nations. So we have to consider exploring the other alternative approach in relevant to the context of the legislation, so that we can accommodate and we can create the law to be considered consistent and congruent with this particular recent development in the internet. And then we have also the second challenge or issue in relevant to the cyberspace, usage of the ICTs in various ways in crime preparation and execution. So this is actually a major challenge, having considered the existence of the cyberspace. So this challenge needs new investigative instrument and precaution over privacy invasion of the internet and sophistication of the cyber crimes. So this continue to outpace the ability of the legal system to respond. So the attribution problems makes policing and the accountability particularly difficult. So it's very difficult to address this important aspect of the accountability if we cannot utilize, and we have to handle the recent or the modern instrument covering this scope of the development. So it will be making the task or the responsibility of the enforcement bodies, including the police department, facing the difficulties of the challenges to be addressing all the recent categories of the cyber crime. So we have to utilize the modern instruments are very relevant for the investigation involving these cyber crimes. And then the offenders nowadays use ICTs in various ways in the preparation and the executions of their offenses. For example, they have utilized the technologies of the cloud computing, botnets, many kinds of the term constantly used for this category of the cyberspace. For example, they have used specific or the special encryption or other clouds available in the cyberspace. And this can complicate the investigation of the cybercrime. At the same time, it's very difficult or challenging to protect or to secure information from the access by the unauthorized people or individual. Having considered all these elaborations of this particular challenge, so we can say that the law enforcement agencies need the education acts. So it's very important to adopt this particular solution so that we can equip with the instrument for these particular enforcement bodies. And then some of the instruments such as the data retention could interfere with the rights of innocent internet users. So this is relevant to the issue of the intrusion of the privacy. So that this is another relation relevant to the internet and other cyberspace platforms. And then if the severity of the criminal offenses is out of the proportion with the intensity of the interfere, the use of the investigative instrument could be unjustified or unlawful. Because there are certain instruments that can be addressing all the challenges involving the cyberspace. But at the same time, there is also the existence of the important issue relevant to the infringement of the privacy, so that it will be considered as the added challenge to the enforcement bodies, having considered all this kind of the risk to the privacy and others. So that it's very important to regard this challenge as the other category of the aspect that should be given the constant attention. And then we have to note that the important consequence from which are very important for the investigation must be introduced, but at the same time, we have to note the existence of the challenge irrelevant to the infringement of the privacy. Next, let's go to the third category of the major challenge involving the cyber crimes. There is the limited international coordination. So this means that there is the lack of, so as a result, there is no centralized international cyber threat information sharing or a common computer incident responses team. So this is also to be regarded as the significant challenge and issue that should be given some kinds of the consideration and approaches to address it. So meaning that we have a certain challenge involving the coordination of the international bodies, 3 countries, irrelevant to the commissions of the cybercrime. So many data transfer processes affect more than one country. So this is another further. At the same time, there are also some kinds of the issue based on services from abroad. For example, the host providers may offer web space for rent in one country based on hardware in another country. So if the offenders and the targets are located in different countries, operations of the law enforcement agencies in all countries affected. So meaning that the cybercrime will be more challenging to enforcement bodies if this cybercrime will be involving so many kind of spots or the premises for the commissions of the crime, not to be limited within one particular country or one particular context of the crime. And then irrelevant to this challenge, the national sovereignty does not permit the investigation within the territory of different countries without the permissions of the local authorities. So this is also another relevant issue involving the crimes in the cyberspace. It is difficult to base the cooperation in the cybercrime on principles of the law enforcement agencies. So it is a hindrance to the investigation, and it also one particular countries involved, and then to be considered within the context of investigation. So how can this investigation be extended to the other country which has not criminalized that particular behavior? This is only the example, irrelevant to this major challenge. Now let's go to the last slide of my presentation. So this is concerning my suggestions, which is my humble recommendation with regard to the available challenge or issue pertaining to the cyber crimes So I would like to highlight these two main categories of the solutions or the approaches that are very essential or crucial to be practiced in order to cope and to try our best with regard to the cyber crimes. The first one, developing based on the appropriate principles. For example, we have the principle of deterrence and restorative justice principle, and we have also the other wide-ranging viable methods forward addressing cyber crimes. So all these principles and the methods are very necessary to be adopted and to be constantly practiced in order to address all the challenges in relevant to the context of the cybercrime. It is consistent to the strategy to increase the capacity for the enforcement and security agencies. So this is particularly significant, having considered the capacity and also the capability or the limitations of the enforcement bodies in many countries, including in Malaysia, in Indonesia, and many others. So that is very important to incorporate many relevant and fundamental principles to create, to plan and to implement the suitable practices with regard to the enforcement and the other relevant. So it is consistent that this particular important strategy is very significant and needed to increase the capacity of the enforcement and the security agencies. And at the same time, it's very good to have this particular updated instrument to upgrade the protections of the cybercrime victim, as well as to intensify the cybercrime prevention. And then can be covering the government or the industry's adoptions of the baseline standard for the suppliers of the digital services based on the self-regulation principle. So we cannot rely heavily on the legislation on the part of the government or on the part of the federal stage, but we have to enforce the self-regulation concept within the context of the companies involving in supplying the networks or other services in the cyberspace. And then we have also the need to extend the application or the equipment procurement, and it can be inclusive of the email tracking system and the investigative toolkit, and we need to upgrade the forensic capabilities. At the same time, we need also to develop the concrete technological guardianship and to establish an effective coordinating body to integrate and monitor the cybercrime matters, including the enforcement matters and enlargement of the international cooperation. And we have to try our best to use the international platform to harmonize the laws of many countries involving the cyber to the context of the existing challenges involving the solution or the tackling of the cyber crimes. With that, I would like to highlight my final remark, cybercrime cognition and conscious support. So let's we work together in combating the cyber crimes. With that, wabillahi taufiq wa hidayah, wassalamualaikum warahmatullahi wabarakatuh. Thank you very much.
Waalaikumsalam. Thank you, Prof. Yusramizza, for your presentation, and it is very insightful. May all of us get the value and benefits from it. And I would like to recap some of the presentation from the from Prof. Yusramizza. Based on the presentation from Prof. Yusramizza, it turns out that cybercrime has been happening for a long time. The first officially recognized cybercrime happened in 1964, long before the internet was introduced, both in Indonesia and Malaysia. And cybercrime apparently also has many kinds and exemplified. In Malaysia earlier, there are cyber harassment, fraud and forgery, malicious code, and others. Earlier, we also explained the legal regulation in Malaysia related to cybercrime, and there are several issues and challenges emerge. The first challenge is in drafting national criminal laws, and second, the use of ICTs in various ways in crime preparation and execution, and the third, limited international coordination. Followed by suggestions and hopes from Prof. Yusramizza, such as we need to develop a comprehensive and updated legal framework on the appropriate principles. And also we need various approaches which must be undertaken. So now we come to the next session, and the final session, and that is Q&A session. But before we start this session, we would like to convey an apology from Prof. Kelik Wardiono because he couldn't join us until the last session because there were other agendas that were just as important. So for this Q&A session, questions from participants can be addressed to Dr. Husna or Prof. Yusramizza. So now for the maybe first section, we will have 3 questions. If participants have any question, you can use the raise hand feature on your Zoom, or you can use the chat room to type your question. Maybe the first question from Nabila Rahmawati. Time is yours.
Okay, thank you very much for our speakers today. And I have some question for Dr. Husna Sarah. I'm really interested with your presentation, Dr. Husna Sarah, but let me introduce myself first. My name is Nabila Rahmawati Rama. I am a student at University Muhammadiyah of Surakarta. As we know, in Indonesia today, so much manipulation of our data. Sometimes, if we want to register anything, we must include our email or number in KTP card, or phone number and anything else. If Indonesia, there was a PDP or protection of personal data and become in regulation laws in 2022. But I think it's this era it's still same. I think it's not effective. We are going to a free era about our privacy data. Okay. Let me continue first. Prevent the misuse of data by irresponsible parties. So I think in this era, it's so easy to get our personal data. I want to give an example case. In the US, there was an amazing web service. There was a company that offers various computing service that allow users to store and manage various types of data, including various personal data such as financial data, payments, and other personal data, and promises customer data security. So the question is how we can anticipate save our privacy data as well, and how the solution for today so many company that use illegal data for political interest or for personal interest. That's my question. Sorry, because my English is still bad. I hope you can get the point. Thank you.
Okay, thank you for your question, Miss Nabila. Okay, first of all, let me give a disclaimer because I'm not from law, so I'm from IT. So based on my understanding of your question is that how are we going to protect our data if it's stored in cloud, right? Like Amazon Web Services. Okay, usually if you subscribe to the AWS services, you would have to read the terms and conditions, and they will ask you to sign an agreement whether you agree or not. So as a user, you should properly read the terms and conditions stated in the agreement. So that's where you know where are your rights and also what are the responsibilities of AWS as well. So supposedly the data that you store in Amazon, in the cloud, should be well protected. So I think there are also terms and conditions that they have to comply, and also you as the users have to comply to ensure that the data privacy is protected. I hope that answers your question.
Okay.
Okay, thank you.
Okay, thank you for your feedback. Thank you, Doctor.
Thank you so much, Dr. Husna, for answering the question from Nabila. Okay, maybe next participant, Ani Farida.
Terima kasih atas waktunya. Saya ingin bertanya kepada Prof. Kelik, apakah Prof. Kelik masih join?
Mohon maaf Ibu, Prof. Kelik tidak bisa lanjut karena ada agenda.
Bisa disambut. Terima kasih. Waalaikumsalam.
Baik. Waalaikumsalam. Okay, maybe the next participants, is there any, or we can go to chat room. Maybe the first from Mr. Saifuddin Judi. So in April until May, the ledger Islamic Bank Indonesia was hacked, as I mentioned before, the PSI, or Bank Syariah Indonesia, so that a lot of customer data was leaked. As customers, what can we do about these banks and the hacker? Maybe in the Malaysian perspective, if that happened in Malaysia, Dr. Husna, please.
I think it also happens in Malaysia. Okay, there are a lot of data has been hacked, and also data leakage and data hacking. Okay, so what they did was the bank just sent an apology notice in the public, and then they would say that they will try to make sure that it doesn't happen again. But usually we don't know as customers, we ourselves, we are not really sure whether our data has been hacked or not, unless suddenly we get all these weird calls from the scammers asking us to invest or to pay something. So but we have, I think now we can actually complain to the tribunal pengguna, or consumer tribunal in Malaysia. So if you suspect that your data has been hacked by your bank, which is actually hard to prove, because there's so many banks in Malaysia, and usually one person will have more than one account. So even myself have more than one account. So if I were to say that my banking account from bank 1, bank A, for example, it maybe comes from bank B. So it's actually, as a consumer, it's very very intangible or very hard for us to find hard evidence to actually go to the tribunal pengguna unless we have, proper evidence. So what we can do, we can just make a police report, and the police also couldn't do much. Okay, there's a lot of scammers. Many people will scam with their money, but they never get back their money, unfortunately. So we just have to be careful with all these tactics. May Allah protect us all, inshallah. Thank you, Mr. Saifuddin, for your question.
Thank you, Dr. Husna, for the answers. Okay, we move to the next question. Maybe is there any participants who wants to ask directly before we go back to the chat room? Okay, maybe we move to the chat room first for now. Question from Mr. Budi. It is necessary to examine consumer data protection using a holistic approach through system design that incorporates legal, administrative, and technical protections. Regulations, especially regarding how companies collect, store, or share the data, consumer data, still need to be comprehensively implemented. In the midst of limited regulations regarding existing company law, what system design and technical forms should companies start implementing to protect and secure consumers' personal data, both internally and externally? Maybe you can help from the experience in Malaysia.
Okay, thank you, Mr. Budi Santoso, for your question. Yes, we need to examine how we are going to protect data protection, how we're going to protect our data, sorry. So there are regulations in Malaysia and also in Indonesia is coming on board as well. So for the companies, I think from my reading in the websites and also in the journals, the companies, they need to have a framework or a proper planning on how they are going to collect the data, because in PDPA 2010 in Malaysia, they clearly listed what are the responsibilities of the company, from the data collection and then the data usage, data storage, until the data, how they destroy the data as well. So in Malaysia, if the company has been found to does not comply to the law, let's say somebody reported the company, so they were actually going to be given a notice, and they actually have some time for them to make sure that they can take the necessary actions to ensure the data protection. So if I'm not mistaken, some of the law companies, some of the lawyers here, they do provide the service on how the companies can comply to the Data Protection Act, PDPA. So there are these companies who has been served notice that can go to the legal services, and the legal services, the lawyers, they can come up with a plan on how to ensure that the data are properly protected. But on their side, from the company side, they also have to be ready in investing in proper hardware, proper software, especially if it's digital data. I hope that answers your question. Thank you, Mr. Budi Santoso.
Thank you, Dr. Husna.
Thank you.
Okay, so maybe we can open one or two more questions before closing the main session, if there is any question. So I see in the chat room that the Prof. Yusramizza cannot continue until the closing session because she needs to return to important physical meeting in with Ministry in Malaysia. So, is there any more question from the participants? You can ask directly. You can open your mic, or you can type it on the chat room. Okay, so if there is no more questions, I would like to close the session. Okay. Finally, we come to the end of the main session. After this, I will return it to the MC to then continue with a break, maybe for 30 minutes. Okay, until 12:15. Okay. Jam 12:15 untuk para peserta sekalian ya. So after this, there will be a break before continue with the parallel session for participants for the call of the call for paper that will be divided into several break rooms. So before we close this main session, I would like to express my deepest gratitude to all of the speakers for taking the time today and willing to join us in ICRT Law. Thank you so much, Prof. Kelik, Prof. Yusramizza, and also Dr. Husna. To close this session, let's reciting Hamdalah. Alhamdulillah. Ladies and gentlemen, and especially the speakers, thank you very much for joining us today. Wabillahi taufiq wal hidayat. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, everyone. Assalamualaikum.
Waalaikumsalam
warahmatullahi wabarakatuh.
Okay, before leaving for break, I need to. Okay. Ada pengumuman ya untuk para peserta. Silakan melakukan presensi. You can fill in the attendance list. I will share the link chat room. Please make sure your name is correct, because the name that input in the Google form will generate as a certificate. Harap diperhatikan agar penulisan nama tepat, karena akan langsung di-generate ya secara otomatis ke dalam sertifikat peserta non-paper ya. Oke. Okay, so now I will return it to the MC. Thank you.
Okay, ladies and gentlemen, finally now we have reached the end of this public lecture today. Thank you very much for all of the presenters for the great presentation. We are so lucky for having you today. I said again, thank you very much. And also I would like to say thank you to all the participants for your active participation. Let's close this agenda by reciting Alhamdulillah together. Alhamdulillahirabbil alamin. I am IC Azara as the master of ceremony. Absolutely have many mistakes. I do apologize. My God bless us forever. And after this, we will break for a while and continue the presentation session at 12:15. Please, for all the participants, you can join Zoom again on time. And please pay attention with your article code to joining the break room session. And the last, I will say thank you very much again for your attention. See you in another agenda. Wassalamualaikum warahmatullahi wabarakatuh.